All righty. Well, good morning and welcome to the First District Court of Appeals. This morning we have two cases scheduled for argument. The first is case number C210252, Montgomery at CareCore LLC, DBA as CareCore at Montgomery versus Rita Abbott. If parties can please identify themselves and their readiness to proceed.
David Brown, Your Honor, for the appellant, Montgomery at CareCore LLC. Ready to
Good
proceed.
morning. Thank you.
And George Parker for Rita Abbott.
Good morning. Attorney Brown, would you like to reserve time?
Yes, please, 5 minutes. Thank you.
5 minutes. Okay, whenever you're ready.
Great. Thank you, Your Honors. And thanks for this opportunity to meet with you via Zoom today. Our appeal in this case is fairly simple. It's our belief that and argument that the trial court committed reversible error by finding that the appellee was not a party to the admission agreement, and that she could not be held liable, therefore, for breach of contract. The admission agreement in this case specifically names the appellee, Rita Abbott, as the sponsor. As the sponsor, it makes clear that Rita Abbott, in the event that the sponsor, has legal access to the resident's income or resources, the sponsor shall pay for services provided by the facility from said income or resources. Additionally, in Section 13 of the admission agreement, it indicates that the sponsor, in the event that the resident's income is reduced to the extent that the resident is ineligible or eligible to receive state Medicaid assistance, the resident or the sponsor agree to apply for and diligently seek the assistance. So there's two responsibilities that the sponsor has under this admission agreement. She agreed to use the resident's resources to the extent that she had access to those resources to pay for the resident's bill. And she agreed to apply for and diligently seek Medicaid assistance once those resources were depleted. In this case, the appellee did have access to the resident's checking account at PNC Bank. She transferred $11,000 from that account from the decedent to the decedent's wife. And she left, minimal amount of funds in that account to pay for the resident's stay at the facility.
Now, how do we reconcile the language that you are relying on with the language entitled liability of responsible party for residents' charges? And there it says a responsible party does not assume personal financial responsibility or liability for the resident's charges.
Yeah, sure. What that's getting at is the sponsor is not a personal guarantor, okay? The sponsor is not agreeing to pay the resident's bill as it becomes due. The sponsor is simply promising the facility that if she has access to the resident's income, she will use that income to pay the resident's bill as it becomes due. Now, this is absolutely necessary in nursing home situations because the majority of the time you're dealing with a resident who doesn't have the mental or physical, wherewithal to receive mail, analyze it, pay their own bills, all of those things. I don't recall off the top of my head what the resident Lloyd Harrison was in the facility for, but I don't think he was capable of handling his own financial, resources in this case. So the difference is a personal guarantor is liable for the entire bill. If $10,000 is billed, the personal guarantor is liable for $10,000 under a personal guarantee. In this case, if $10,000 was billed, but the sponsor can prove that they only had access to $2,000 of the resident's funds to apply towards the bill, then they would only be responsible to the facility for turning over $2,000 because that's all they had access and control over. And all they did was promise to use the resident's funds to pay, not their own. So in this case, what we have is we have somebody who had access to the resident's PNC checking account. We've shown that there was at least $11,000 in that checking account that was available to pay for his stay. and that $11,000 was turned over to the decedent's wife rather than to the facility. In that case, $16,000 was billed in this case. $11,000 was available to pay the facility, and it wasn't turned over. In this case, the damages would be $11,000. She had access to the PNC account. She was the power of attorney. She could have turned that $11,000 over to the facility. Instead, she transferred it to, I don't know if it's her mom, but it's the decedent's wife. So the calculation of damages would be $11,000, not the full 16 that was billed. Additionally, once the funds were depleted in the PNC bank account, she had the responsibility under the agreement to apply for, and diligently seek Medicaid assistance. Once it was shown that the Medicaid application was filed, that Medicaid application was denied because of failure to verify, which means that Jobs and Family Services requested information from the sponsor. She failed to provide them with the information that they requested, and therefore the application was denied. Additionally, she failed to establish a QIT, which is a qualified income trust for the resident that was required by JFS. Again, after being asked, numerous times to do so. So, again, the argument that plaintiff or appellant in this case is seeking to hold the appellee liable under a personal guarantee is just simply false. The sponsor signed the agreement. She agreed to participate in this transaction in a specific way, and that was to turn over funds of the residents that she had access to and to diligently cooperate with the Medicaid application process. She clearly failed to do those things in this case. And the court's insistence that she had no responsibilities under the contract is simply false. She did not, and we agree, and we have never alleged that she had a responsibility to pay the resident's bill from her own funds.
Mr. Brown?
Yes.
In comparing the language in the Miracle case to the language in this case, in the Miracle case, it says that the responsible party does not assume personal liability or personal financial responsibility or liability for the resident's charges. But in this case, it simply says a sponsor may acknowledge this agreement without incurring personal financial liability. It doesn't specify what personal financial liability means. It doesn't say for the resident's charges. It's a really broad phrase. So how are we to interpret that?
Well, again, if the contract, there's no contract, if we're going to say that the sponsor in this case signed the admission agreement, with no promise to pay the facility from the resident's funds, that doesn't make any sense. Then there's no contract. It just makes no sense. Now, I guess what you're getting at is she's not agreeing to be held liable in the event that she breaches the contract. Well, then again, we don't have a contract. There's no contract. And in that case, the appellant would have had no responsibility to provide the resident with services. Clearly, that's not what was intended here. The resident was admitted to the facility. CareCorp provided him with care for a significant amount of time. And they relied on the sponsor's promise to pay from his resources to the extent that she had access to those resources. The thought that she could not then be held liable for her breach of the contract, which again, she promised to pay from his resources to the extent that she had access and to cooperate in the Medicaid application by diligently seeking Medicaid benefits. If she can't be held liable for those breaches of the contract, then the contract isn't worth the paper that it's written on. Every admission agreement, is going to be different. depending on the facility that we're dealing with, because these aren't standard contracts that every facility has their own admission agreement. But the case law is abundantly clear that in these nursing home scenarios, residents are routinely incapable of providing for their own payment and dealing with their own finances. And the establishment of a system of sponsors or responsible party or representative or whatever the facility wants to call it in their admission agreement is permitted, expressly permitted by federal law to provide for payment to the facility from the residents' funds. That's all this was. This is not an attempt to hold the sponsor personally liable from her own funds. She's being sued at this point for breach of contract because, again, she failed to perform under the contract by failing to turn over the residents' funds as she promised she would do. And again, failing to diligently seek Medicaid assistance.
Council, you have about a minute left. And of course, if there's any other questions.
Yeah, I will go ahead and defer unless you all have any further questions.
Okay, thank you. Attorney Parker. Attorney Parker.
Well, I diligently turned my microphone on mute and didn't turn it off. Sorry.
No
Please,
worries
the court.
at all. No worries.
Yes. And counsel, I want to point out to you that you asked a question that distinguished counsel didn't respond to, and he didn't respond to it because he has no answer. You see, this case is less about the issue of who pays for Mr. Harrison's care as it is about a complaint that was not well pled. I think they have admitted that they've sued Ms. Abbott individually, yet they want to hold her responsible for her failure to perform in a representative capacity. And clearly, she had no individual liability, yet they are still saying that she individually breached the contract, which is why the trial court judge very succinctly and appropriately said, if you would have wanted her to perform in a representative capacity, you should have sued her for specific performance, and that would have been in the representative capacity. So to try to now have her be individually liable is the reason why there is no genuine issue material fact. You know, the other thing that counsel failed to point out is both federal and state law prohibit there from being an attempt to try to make a third party liable. And in fact, they pled it in their complaint. The federal code sections, the federal regulations, and the state regulations that prohibit there from attempt to try to make a third party liable. What Ms. Abbott is alleged to have done could only have been in her representative capacity, and the two causes of action here name her personally. So it was eminently appropriate for the trial court in a 2-page entry to first make a decision that there's no genuine issue material fact with regard to the allegations as alleged in the initial cause of action, the breach of contract, because she couldn't have breached it individually. Maybe they're alleging that she breached it as a sponsor now, but they didn't allege that in the complaint. It's very akin to suing a corporate officer for a corporate obligation, trying to sue them personally. So the trial court analyzed the allegations in the complaint, looked at the answers to the discovery, looked at any affidavits that were attached, and they made an appropriate decision. Now, your review is de novo, so each one of you will be, I suspect, looking at the contract, making a determination of whether or not the allegations, whether or not there's any genuine issue material fact. And I'll point out again, they sued her as Rita Abbott, not Rita Abbott as the sponsor of Lloyd Harrison, not even as they're trying to stretch it today, Rita Abbott as the former attorney in fact of Lloyd Harrison who had access to particular assets of Lloyd Harrison, which kind of circles us all the way back to the Embassy Healthcare case, which I think is going to be also persuasive in this case, because what the Supreme Court of the state of Ohio said is you have a debt between a healthcare provider and an individual who the healthcare was provided to. And you have a certain amount of time after the death of the person who the healthcare was provided to open an estate and file a claim against the estate and to recover any assets that you believe may have been dissipated in the estate and then distribute those assets appropriately. That wasn't pled here. Thank you.
Thank you.
Thank you, Anna. May I proceed?
Yes, absolutely.
Okay. I think I recognize now what the misunderstanding is. So this idea of that Rita Abbott was sued individually and not in her representative capacity. This complaint has been filed without incident thousands of times across the state of Ohio. Again, as I mentioned previously, the structure that exists to have a sponsor or a representative or a responsible party is specifically provided for by federal law. This is not an instance of suing someone for a personal guarantee. I can't state that enough. If this was an instance of suing someone for a personal guarantee, then we would be seeking damages for the amount of the unpaid bill, period, without any, looking into whether she even had access or control. She wouldn't even need to have access.
Mr. Brown,
or control.
Mr. Brown,
Yeah.
I understand the distinction that you're making. I get that. My question for you is, do you have, and you said that there's been a lot of cases on this, do you have any specific case law that uses the same language you had in your contract? The person can sign it without assuming any personal financial liability. Do you have any case law that uses that language that's in your favor?
I don't know of any cases that have made it to a court of appeals that have used the exact language from this admission agreement. I doubt that exists. I haven't seen it.
Thank you.
There are, as I've cited in our appellate brief, numerous cases which outline the structure that we have here with the sponsor, responsible party, representative, whatever.
Mr.
In
Brown,
this case,
I think
I understand what you're saying. In this case, if she wanted to sign in a representative only capacity and not be liable for what she promised to do under the admission agreement, then she should have put POA beside her name or indicated that she was signing in some capacity, some representative capacity other than her personal capacity. She could have simply said she was signing as POA. She could have written representative by her name. She could have written guardian, whatever she had, whatever representative capacity she wanted to sign us in. At the end of the day, she signed in her personal capacity. She simply signed her name, and she agreed that she freely consented to be legally bound by all of the terms of the admission agreement. Now, the admission agreement specifically stated that if she had access to the resident's funds, she agreed to pay those over to the facility. She did in this case. She did have access. She was a power of attorney on his bank account, and she could have turned those funds over to the facility for payment. She didn't do that. Therefore, it's a breach of contract. Now, it's
Attorney
only a
Brown.
breach of contract for the
Attorney
amount that,
Brown,
yes.
Let me ask you a question. And so going back to the language, personal liability, what does that mean to you?
Personal liability means when we send a bill to you, you're going to pay it. You're personally liable for it. Okay. In this case, she was not personally liable to pay that bill. She was not required to pay the bill from her funds. She was simply agreeing to act as a conduit to pay the facility from the resident's resources. The resident was clearly personally liable for the care that he received. The resident had to pay for the care he received, but he was incapable of doing so. So the facility needed to, engage with someone who had access to his funds to turn those funds over. Now, had she paid the facility from the resident's funds and there was a balance left over at the end of the day, say that she did apply that 11,000 and we had an additional, $4,000 or $5,000 left over, say $5,000 that was unpaid. She would not in any way be responsible for that $5,000 because she didn't have access to any additional funds of the resident. But in this case, she agreed to turn over the resident's funds to the extent she had access, and she failed to do that. So again, her personal liability, she right now, what this complaint attempted to do was to hold her liable for her breach of contract. She promised to pay from his funds and she failed to do that. She promised to diligently pursue Medicaid and she failed to do that by failing to turn over the verifications and establish the QIT as she was asked to do. Those are a breach of contract. They do not result in the same amount of damages perhaps as would have resulted if she was personally liable under a personal guarantee or something like that. But that does not make her a personal guarantor, and this case is not about the enforcement of a personal guarantee. She made promises in the admission agreement, and she breached those promises. If we're going to hold that she didn't make any promises in the admission agreement to turn over funds that she had access to, then again, there was no contract in this case to begin with. And that's simply inconsistent with all of the cases that we've cited in our brief.
Thank you, Attorney Brown. Unless there's
Thank
any
you.
other questions from the panel. Okay, we thank you both for your arguments this morning. We
Thank
will
you.
be taking the matter under submission and issuing a timely decision. And we
Thank
wish
you.
you a wonderful week.
Thank you.
Thank you, everybody.
Thank you.
And that's
Attorney Brown, unless there's
Thank
any other questions. Thank you both for your arguments this morning.
Thank you.
Good morning. We're here on our second case, which is case number C210165 and 175, Joseph Fairless versus Acuity, a mutual insurance company. If parties can please identify themselves and their readiness to proceed.
Good morning, Kate Kennedy on behalf of Acuity, the appellant and cross appellee. We are ready to proceed.
Thank you.
Good morning, Your Honor. Joshua Smith on behalf of the appellees and cross appellants, Joseph Fairless and Bayberry Crossing LLC, and we're ready to proceed.
Okay. Attorney Kennedy, would you like to reserve time?
Yes, I'd like to reserve 3 minutes, please.
Okay. And Attorney Smith, would you like to reserve time?
Yes, Your Honor. I'd likewise like to reserve 3 minutes.
All right. Attorney Kennedy, whenever you're ready.
Thank you, Your Honor. May it please the court, opposing counsel, Mr. Smith. As I said, my name is Kate Kennedy and I represent Acuity, a mutual insurance company. This is an insurance coverage dispute. Acuity issued an insurance policy to Brook Meadow LTD in effect from July 2014 to July 2015. In November 2014, Gavin Connor was injured at an apartment complex owned by Brook Meadow in Claremont County, Ohio. Mr. Connor subsequently filed suit in Claremont County Court of Common Pleas against Brook Meadow. Acuity defended Brook Meadow in that suit pursuant to its policy. During discovery in that case, Brook Meadow, it was discovered that at the time of the fall, Brook Meadow had entered into a commercial lease with the property with an option to purchase to the appellee, Joseph Fairless. As lessee, Mr. Fairless took the property as is and was required to keep and maintain the property in good repair. He also agreed to maintain a policy of insurance. In 2017, Brook Meadow filed a third-party complaint in that Claremont County action against Mr. Fairless and Bayberry Crossing LLC, the appellees in this case. The third-party complaint cited the commercial lease with Fairless and Fairless's duties to maintain the premises in good repair and condition.
And didn't that third-party complaint also allege that Bayberry was a manager of the property?
Yes, the third-party complaint alleged that Bayberry Crossing was a lessor, operator, and manager of Bayberry Apartments. But Your Honor, it did not allege that it was Brook Meadows' actual property or real estate manager of that premises. After Mr. Fairless was served with the lawsuit, he turned it into Acuity and requested a defense. While Acuity,
You're fine.
thank you. While Acuity was investigating the claim for a defense, the underlying Connor lawsuit was settled, and Mr. Fairless nor Bayberry ever had to file an appearance or even enter an answer in the lawsuit. Subsequently, Mr. Fairless initiated this lawsuit, which, as you know, is a declaratory judgment action, a breach of contract action, and a bad faith claim against Acuity, in which Mr. Fairless alleged that he was insured under Acuity's policy with Brook Meadow. 8 months into the lawsuit, Bayberry Crossing was added as a plaintiff as well. There are two issues for the court on appeal. The first is whether Acuity had a duty to defend Mr. Fairless and Bayberry Crossing against Brook Meadows' third-party complaint. And then the second issue is that if there is a duty to defend, what is the proper measure of damages for breach of the duty to defend? On the first issue, it is Acuity's position that the trial court erroneously determined that Acuity had a duty to defend Mr. Fairless and Bayberry Crossing. It's undisputed that Acuity's policy was issued to Brook Meadow LTD, that's the named insured. It's also undisputed that Mr. Fairless is not a named insured or an additional insured under the policy. In the trial court, Mr. Fairless
Now,
contended—
Mr. Fairless was the one that was actually paying for the policy, the premiums on the policy.
That is my understanding through discovery in this case, Your Honor.
Okay.
During the trial court, Mr. Fairless contended that he was an insured under the policy under Section 2, who is an insured, which provides that any person or organization, while acting as your real estate manager, is an insured under the policy. Acuity's position and view is that the policy defines you and your as Brook Meadow LTD, the named insured under the policy. Under the policy, coverage is afforded to any person acting as Brook Meadows real estate manager. It's our position that the evidence in the record is not that Brook Meadow ever hired or paid for Fairless to be its real estate manager for the property, nor were there allegations in the third-party complaint that Fairless had been hired to be Brook Meadows real estate manager on the property.
But does it require for Fairless to be hired? Because the language in that original agreement from 2013 basically is assigning all the responsibility and the sole discretion to Fairless to keep and maintain, and absolves your client. It says that Fairless is waiving all rights to the leaseor to repair and maintain. So it has that language. Additionally, it has the language that it says leasee, which is Fairless assumes the management and operations of the premises. And there's also language in there when it comes to the tenants in that same conditional assignment of rents and leases provision. So what your argument is that he was never paid for that role. My question is, isn't the contract by its language assigning? Isn't there an argument that he's being assigned that role?
The contract itself authorizes him to assume the management and operation of the premises. It doesn't assign it to him. In Section 23 of that agreement, he's authorized to do that. But if we take that logic that anyone who's assigned to be the property manager or the real estate manager, that they're going to be covered under insurance policy defeats the intent of the policy. Like under that logic, the actual property management company that we learned that Fairless had hired to manage the property, Sundance, they would be considered an insured under our property as well, because they had assumed the role as property manager. And that's not what's contemplated by the policy. It's our position that the policy would cover Brook Meadows, someone who Brook Meadow had hired or retained to act as the real estate manager of the property. There was also a contention in the trial court that Bayberry Crossing LLC was considered an insured under the policy. And as we set forth in our brief, Bayberry Inc. is identified as an additional insured under the policy, which I understand Mr. Fairless suggests is a typo, but there is a limitation to their status as an additional insured. They are only considered an additional insured as for liability as the co-owner of the premises. During the time that the events to Mr. Connor occurred, or the time that Bayberry Crossing LLC and Mr. Fairless were named in a third-party complaint, Bayberry Crossing LLC was not a co-owner of the premises. The owner of the premises was Brook Meadow LTD. So it's our position that as Bayberry Crossing LLC, as well as Mr. Fairless individually, are not insureds under Acuity's policy.
Ms. Kennedy, I want to go back for a second. So under Ohio law, and the duty to defend is broader than that to indemnify. It's according to review the allegations in the complaint. So the complaint says that Bayberry Crossing LLC was the lesser operator and manager of Bayberry Apartments. So just looking at the complaint, doesn't that indicate that they're a manager, that it's a manager?
Not that they are Brook Meadows manager, that we hired them to be the real estate manager on the property. As I mentioned before, it's not just we can't extend coverage under Acuity's policy under any entity that is going to act as a manager on the property. That would go beyond the scope of the policy.
But
But Your Honor,
I'm going to turn back to the language of the contract. And this goes to the question that you were just posed by Judge Bach. So you've got the complaint, and the language in the contract is person or organization acting as your real estate manager. So it only requires for that person or organization to be acting as the real estate manager.
That's correct. That is what the policy says.
So what is your then interpretation as to what that language is intended to reflect?
Well, for example, if Brook Meadow had entered into a property management agreement with Mr. Fairless or some other entity, such as the one entered into with Mr. Fairless with Sundance Property, that would be an example of a property management agreement where you're hiring somebody, you're compensating somebody to be your real estate manager on your property. And that's not what the agreement was between Mr. Fairless and Brook Meadow.
Wouldn't that be a more narrow interpretation than the language acting as?
I don't believe so, Your Honor. And Judge Bach, going back to your point earlier, and I don't disagree with the standard under Ohio law for the duty to defend, and the duty to defend being broader than the duty to indemnify. I know I have a few minutes left, and the second issue that's on appeal is if there was a finding that Acuity breached its duty to defend Mr. Fairless and Bayberry Crossing, what is the proper measure of damages? And at the trial court determined that at this stage of the litigation that Mr. Fairless was entitled to his costs and attorney's fees that he incurred in connection with the defense of the underlying claim. And we agree with the court's decision, and we would ask the trial court's decision on that be affirmed. As we set forth in our briefs into the trial court, Ohio adheres to the American rule, which states that a prevailing party in a civil action is not entitled to its attorney's fees unless certain exceptions apply. Those exceptions include authorization by statute, a contractual fee shifting provision, or when a prevailing party demonstrates bad faith or vexatious behavior on the non-prevailing party. And this case is where we are now, is the declaratory judgment stage of this case. And as we cited in our brief, Revised Code 2721.16 expressly prevents the recovery of attorney's fees in a declaratory judgment action unless there's a finding of punitive damages. It's
Ms.
our
Kennedy,
position-
just to clarify, the trial court has not determined whether there was bad faith, correct? Either way.
That's correct. That's correct. That's still pending. It's a pending claim. It's our position that Mr. Fairless is entitled to just his fees incurred in defending the underlying action. Acuity's policy does not provide for contractual fees in a dispute between Mr. Fairless and Acuity. The statute expressly prevents the award of attorney's fees. And it's our position that unless and until there is a finding of bad faith, Fairless is not entitled to his attorney's fees in prosecuting this action. And I would also point out that the trial court's decision on this issue, while brief, was in her discretion. She did not make any type of finding that Acuity had engaged in behavior that was vexatious, obdurate, or in bad faith, or demonstrated a stubborn propensity for needless litigation in this case. Therefore, we would ask that the trial court's decision on damages be affirmed.
Thank you.
Thank you, Your Honors.
Attorney Smith.
Thank you, Your Honors. My name is Joshua Smith, and I represent the appellees and cross appellants, Joseph Fairless and Bayberry Crossing LLC in this lawsuit. I want to start with this is a textbook example, this case, of a basic unwillingness of an insurer to defend its insured when they had a clear and obvious obligation to do so under the standards of Ohio law. This has resulted not only in fees incurred by Mr. Fairless personally in the underlying suit, but also over 3 years of litigation since that time, simply to enforce his rights under the agreement to receive that duty. There were a couple points that were discussed in the Appellant's Counsel's arguments that I just want to address here. First, Justices Zayas and Bach, there was some discussion about whether Mr. Fairless was acting as the real estate manager at the time. And I believe counsel referred to the fact that Mr. Fairless or Bayberry was not hired or paid by Brookmeadow. As the justices pointed out, there's no requirement that either of the appellees be hired or paid within the policy. All that it states is that anyone who is acting as your real estate manager is considered an insured under this agreement. And in this case, the third-party complaint, as was noted, directly implicates that Fairless and his entity, Bayberry Crossing, were acting as the real estate managers at the time that these injuries occurred. For the first thing, the lease agreement is attached directly to that third-party complaint. That in itself is a contract that provides to Mr. Fairless and then assigned to Bayberry that they are going to maintain the property, they're going to repair it, they're going to pay real estate taxes, they're going to assume mortgage obligations, they're going to obtain insurance for the property and name Brookmeadow as an additional insured, and they're going to assume all of the lease agreements under this commercial apartment complex. There's simply no question, especially based on the law in Ohio, as to a duty to defend, which is much broader than a duty to indemnify, that Mr. Fairless was arguably or potentially entitled to a defense because the claims that arose under this complaint arguably put him within coverage. There was also some reference to the definition of your under the agreement. That's a red herring here, and it's easily dispelled by simply looking at the complaint once again. I think the argument is that because the statement of Bayberry was the lessor, operator, and manager of the premises, because it doesn't say that it was Brookmeadow's real estate manager, that he was just a manager, that this coverage doesn't apply. that simply, that goes beyond even common sense, just looking at this lease, which is between Brook Meadow and Fairless. And the allegation that he was a manager, but he wasn't the manager of Brook Meadow, who he has a contract with to perform these duties, just defies common sense, and it can't be supported here, especially under this standard of Ohio law for a duty to defend. There was reference also to a Sundance property management agreement. I do want to just address that briefly. That agreement itself was never disclosed to Mr. Fairless, was never discussed in the underlying lawsuit. There were no communications about that. That only came about in this present lawsuit as a claim that, well, as it turns out, we have some evidence that Mr. Fairless might not have been performing all of the management and repair duties. That is, again, it's an irrelevant question here. The question is the complaint itself that's made against Mr. Fairless. What are the allegations? And do those allegations, as stated, place Mr. Fairless or Bayberry within a coverage provision? They did, and he was owed a defense from that point. The fact is, the duty to defend Mr. Fairless and Bayberry was clear from the complaint. It was clear at the time it was made. It was clear at the time that Mr. Fairless made the request for coverage to Acuity. Despite that fact, he was ignored throughout the underlying litigation. And when he requested reimbursement of his fees, he was ignored again. And that required him to proceed forward with this lawsuit. And that's kind of the segue into the second issue here is, well, okay, we have a summary judgment decision here that Mr. Fairless was entitled to a defense, that Acuity breached that duty. Now the question becomes, okay, is he entitled to those fees in the underlying lawsuit and also the fees in the present litigation? And there is well-settled Ohio case law on this point that has been, that type of award has been allowed in the past, and it continues to be awarded to this day. That started with the Ohio Supreme Court in the case is Trainer. And in that case, the court held that, well, in an action such as this, where an insurer has a basic unwillingness to defend and it's wrongful, then the insured can recover not only their underlying fees, but the fees in the present litigation, because the insured must be put in as good a position as if coverage had been provided. That was then later extended in the Standard Oil v. Allen decision, in which the court essentially was dealing with a contract, not necessarily of insurance, but for indemnity. And the court made clear that in that case, regardless of whether this was an insurance contract or a declaratory judgment action, the legal principle still applies, which is that this indemnity, who was not provided the defense which they were supposed to receive, the breach of that duty not only entitles that indemnity to the attorney's fees in the underlying litigation, but also in the present litigation. In this case, there's been arguments that statutory law prohibits this type of award, and that comes from a 1999 amendment to the Declaratory Judgment Act. And we would submit that if this were only a declaratory judgment case where Acuity had, in fact, fulfilled its duty up to this point, but they were simply seeking a judgment to say that they're not required to do that going forward, that might make sense. But the issue here is Acuity outright failed in its duty from day one, and they never provided any basis for Mr. Fairless as to why they were denying that duty. They simply didn't respond to him. And that required Mr. Fairless to bring forward not only a declaratory judgment request, but also a breach of his insurance agreement and a breach of the duty to defend here. And that 1999 amendment in no way overturned Trainer or Allen. What it did was it looked at another case, which is Brandenburg, and it decided that the effect of that holding should be overturned. And that holding essentially expanded it to the Declaratory Judgment Act to say, well, we have this language of any other necessary relief as just and proper by the court, that can include attorney's fees. That's what was overturned by House Bill 58 in the 1999 amendment. It was not an overturning of Allen or Traynor, and those are still good law. So in a case like this, where you have an insured who has been refused a defense, and the finding is that that refusal was a breach, it was wrong. In that case, these fees can still be awarded. I think there was one other reference in the briefing to a decision by this court, OKL Canline, and I do want to address that. That case, again, concerned a declaratory judgment question, but I think what the argument has been on the other side is that, well, that was an overturning of Traynor, of Allen, and those are no longer good law. And that's simply not what OKL Canline held. It simply found that fees should be awarded, but it did so on the basis of a stubborn propensity for needless litigation. But it never overturned Traynor nor Allen, and those are still good law, and they still should be applied here. To the extent this court does feel that OKL Canline does apply that broadly, it should be overturned, because in this case, well, in all cases, that is still good law. Those Supreme Court decisions are still good law, and House Bill 58 never did anything to overturn those decisions. And then as a final point, even assuming that we don't overturn that and that OKL Canline is good law and that it is that expansive, the fact is, if we look at this case, there is plenty of evidence that Acuity has engaged in exactly the type of conduct that the OKL Canline court would award such fees.
Mr. Smith,
Yes.
if in that case, wouldn't we have to remand it to the trial court to determine whether that sort of behavior happened?
Your Honor, I think this court could make the finding here, because that evidence has been submitted in this case. The court it never considered any of that. I think it would warrant certainly a reversal on the finding, if it's a finding that no fees could have been allowed as a matter of law. That's simply incorrect. If this court felt inclined to do so, it could reverse and ask the trial court to go ahead and make that analysis, certainly. But our position is that this court could make a decision those fees are warranted based on the conduct as established in the record in this case. And that conduct, we need only just look at the record and what has occurred from 2017 to now. It started with Fairless requesting coverage and to his insurance agent, and the agent simply indicating, well, you're not my insured, so I can't tell you anything. When he says, yes, I am, and here's the reasons: I've been paying for this policy, I've been the point of contact for you, and this must be some kind of miscommunication. The agent responds with, well, I've looked at this thing over a few days and it looks like you're definitely the property manager. He indicates you're the owner of the premises, but we're tendering this to you. And Mr. Fairless misunderstands that to believe, okay, tendering must mean that they're giving me this coverage. They're saying these bases as to why I'm an owner, I'm the property manager, and everything in that indicates I'm covered under this policy. And then when he responds with that understanding, nothing from Acuity to say, you're misunderstanding this, nothing of that nature. They continue to say they're assessing, they haven't determined coverage, and they essentially outright ignore Mr. Fairless for months. And when he requests reimbursement after he had to retain his own counsel, he's ignored again, requiring a lawsuit. And what happens from there, I'm not going to go into all of the detail, but it's basically, there was a motion to dismiss, denied. There was a motion to bifurcate not only the claims, but the discovery associated with those claims, effectively creating 3 separate trials, one on the breach of contract, one on the bad faith, and then a third on punitive damages. Then we have cross motions for summary judgment that granted for plaintiff, denied for the defendant, an attempted appeal that fails for subject matter jurisdiction, and then another attempt, which is why we're here today. That encompasses 3 years of litigation and significant fees simply to enforce Mr. Fairless's right to obtain a defense. both Trainer and Allen continue to support that type of award, and this court should continue to apply that standard.
Thank you for your arguments. I'll reserve your 3 minutes.
Great. Thank you, Your Honor.
Attorney Kennedy.
Thank you, Your Honor. Just a few points that I wanted to touch on. This court has looked at Trainer and Brandenburg, which were enacted before the declaratory judgment statute prohibiting the award of attorney's fees. And this court has recognized that those cases support an award of fees where the losing party has acted in bad faith, vexatiously, wantonly, obdurately, or for oppressive reasons. That issue is currently pending right now in the trial court in connection with the bad faith claim. I agree with Judge Bach that if the court is going to make a determination that Mr. Fairless could be entitled to attorney's fees, then that determination needs to be made in the trial court and the case be remanded. I don't want to go into point by point, but let's just say I strongly disagree with Mr. Smith's characterization of the communications between Acuity, defense counsel, Mr. Smith, and Mr. Fairless concerning his request for reimbursement, negotiations, response, his extensions that were provided to him so he wouldn't have to file an answer in the case. So that's all pending and has not been fully developed on the record in the trial court. So it's our position that the trial court's decision that at this time in the litigation, the only fees that Mr. Fairless is entitled to are those that he proved had incurred in connection with the defense of the underlying case. Thank you.
Thank you. Attorney Smith, you have your 3 minutes.
Yes, Your Honor, and I just have one point on rebuttal here. As to the bad faith claim, which remains pending, there's no case law, nor is there an obligation that a bad faith claim must be proven in order to award such fees under counts 1 and 2. We can actually look at OKL Canline, paragraph 39, in which the court makes clear that although the obdurate behavior on which they're finding that fees are awarded is thought of often as akin to bad faith, it's not the same thing. You don't have to prove a bad faith claim in order to obtain these fees. And that's what's being made clear in that paragraph. So contrary to counsel's point, there is no obligation that we have to prove a bad faith insurance claim in order to be awarded these fees. Unless the court has any other questions, we simply close and respectfully request that this court affirm the summary judgment decision as to liability with respect to the duty to defend, affirm the award of the fees for the underlying litigation, but reverse and remand as to the fees to be awarded in the present litigation, with instructions to the trial court to consider those fees and to award them the reasonable fees based on the holdings in Trainer and Allen. Thank you, Your Honors.
Thank you both for your arguments. We will take the matter under submission and issue a timely decision. We wish you a wonderful week. And that concludes our argument.